December dates stacking. Pure courtroom chaos.
He's fast.
Yeah, I'm calling him. I'll text you.
Are y'all ready on DeLeon? All right, Mr. DeLeon, if you'll come down. Good morning, Mr. DeLeon.
Judge checks probation like receipts. Attorney hiding notes?
All right, does anybody have a copy of the motion to revoke?
I do, Judge, but it's full of notes.
Okay, let me see. I can pull it up in the email. Ms. Abrams sent it. It's just, sometimes it's easier seeing the paper.
I wouldn't want to expose this court to the prejudicial notes that I have here.
Oh, let's not do that. And Mr. DeLeon, I'll be reviewing the motion to revoke, not to decide whether or not things are true, but just to make a decision on if I were to grant your motion for a bond, that the conditions I set are appropriate. Okay.
We can do that.
And Mr. Ballantyne, I'm creating breakout rooms, but do not go to the breakout room. It's for someone else.
Understood.
Classic courtroom vibe check. Are we really all on the same page?
Ms. Abrams, do you have a copy of the motion to revoke on Mr. DeLeon? I don't see it.
Yeah, clause number, I don't think it's listed.
All right, it's DC 20.
I'm pretty good for you, Rick.
Oh, thank you.
You're welcome. I already had it pulled up.
Rick is anticipating. I like it.
Teamwork, good.
Yeah, it makes the dream work. All right, while they're printing it out, the court is calling 2024 CR 3774 State versus Luis DeLeon. Could I have parties announced for the record for the state? Defense? For the defense?
Patrick Ballantyne for Mr. De Leon.
And are you Mr. DeLeon?
This one.
State, any objections to the defense appearing by Zoom?
Judge.
And Mr. DeLeon, do you have any objection to your counsel appearing by Zoom?
No.
All right, you are here. Oh, thank you.
You're welcome.
You're here requesting that a bond be set. Is that correct, defense?
That is correct, Your Honor.
All right, and it's the court's understanding that you all have reached an agreement?
We
As to
have.
a Judge, but perhaps not two conditions.
All right. Any witnesses with regards to conditions for the court to set?
Yes, Your Honor, we would call Mr. De Leon.
All right, Mr. DeLeon, if you could raise your right hand. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand, state your name for the record.
Louis De Leon.
All right, defense, you may proceed.
So, Mr. De Leon, the court is presently considering whether to grant you a bond on this motion to revoke, what that bond should be set at, but she also needs to know if there's any special conditions that need to be imposed as a condition of your bond. I'm going to ask you about a couple things in particular. First, I want to start with any history of mental illness that you might have. Do you have, or have you had in the past, a diagnosis for any mental illness or disease?
No, sir.
Are you receiving, or have you received in the past any treatment or therapy for mental health issues?
No, sir.
Okay, I want to ask you also about substance and alcohol issues that you might have. Have you ever received any treatment or counseling, whether court-ordered or voluntary, for any substance abuse or alcohol abuse issues?
No, sir.
Okay. You're under oath, and can you affirm to this court that you do not have an issue with substance or alcohol abuse?
No issue, sir.
Are there any
Alright.
other I'm sorry, are there any other special conditions that you're aware of that this court might need to impose as a condition of your bond?
No, sir.
Okay, thank you, Judge. I'll pass the witness.
Any questions?
And if I may just talk about procedurally, the new case, Judge, not the substance of the new case.
Yes, can you tell me the name of the complainant?
In the new case, Judge,
Yes.
it is Ms. Natalia Aguilar.
All right.
Mr. De Leon, did you get picked up in a pawn set August of 25 this year from the new assault case?
Yeah. Yes.
You get arrested in
Yes.
August.
Yes.
They set a bond.
Yes.
And then was that bond forfeited?
I'm not sure, honestly. I believe last I heard it was like 4,000
Did you get rearrested in that case?
on the incident from August.
Yes.
I turned myself in for the MTR.
You turned yourself in for the MTR.
Yes.
Were you aware that there was a failure to appear in September?
No. When I talked to my probation officer, it was August 27th, I believe, and she said that she was gonna, I guess, I don't know what it's called, but essentially she was gonna, so that there was no violation, she was gonna essentially, I don't know, waive it or something like that. And then once I turned myself in, everything would sort itself out.
Or they set that bond again, September the 4th?
I'm not sure, sir.
No additional questions, Judge.
All right. So do you all anticipate this being a contested hearing?
Unsure.
Well, Your Honor, I guess you've looked at the MTR at this point. There's a new number one that would be contested. The number two allegation, I need to confer with my client, but I don't know that would be as contestable. So I am.
All right.
That's
Ms.
the best
Ferguson?
I can tell the court today.
All right, this is going to be set for a contested hearing. Ms. Abrams, are you able to have, if there's a need for an officer, are you able to have that officer here? We can put it on December, either December 9th or December 16th. All right,
Oh,
yes.
okay. Is December 11th available? Because I have some other cases in your court that day.
All right, let me see. Ms. Abrams, is December 11th?
Yes, Judge.
All right, December 11th. And Yaya, could you do a reset form for contested hearing? So your contested hearing is going to be December 11th. You'll need to be here. If you're not released, you will be brought over from the jail. So the court is going to follow your agreement. Bond is going to be set at $50,000. There's to be no contact with the complainant and the alleged new number one. And state, do you believe you'll be able to contact the complainant to let them know he's received bond today?
Yes, Judge. Cool.
All right,
Is this the complaint on the new number one, Judge, or the complainant on the underlying offense?
both.
We'll let them both know. And for the court, we were discussing several times.
Oh, the defense wrote on here that, that was the original bond amount, correct?
The original was 50,000, that's correct.
That's what was written on. I thought that was the agreement. So do y'all have an agreement or no?
I think we did, Judge, accept that.
All right, then the court will follow your agreement. The court will set your bond at $75,000. As I said before, there's to be no contact with the complainant and the allegation of the new number one. And of course, there's continued no contact with the complainant for the instant case. Do you understand? All right. So parties, if this is going to be contested, you all need to be prepared for a contested hearing on December 11th.
Yes, ma'am. Judge, the state further was asked for GPS, but that part was not.
All right. Mr. Valentine, the state is asking for GPS. You're opposed?
We oppose that, Your Honor. We don't believe it's a necessary condition in this case.
All right. And state, what is the reason for your request of GPS?
The underlying offense, Judge, for which he was placed on probation earlier this year, fled to East and saw, was fled down. So he's only been on supervision for 6 months, 5 months, 6 months before he's rearrested for this new offense, which is another violent offense on the state. He is a danger to
All right. And defense?
I'm having a little trouble hearing Mr. Morris, but I believe the concerns he's expressed would not justify anything like full house arrest. I don't think that GPS is necessary. This is not an instance of some sort of assault or improper contact with the victim in the case before the court. So, Your Honor, we would either ask that GPS not be imposed and that issue be left to the misdemeanor court's discretion handling the new number one, or if the court does see fit to impose GPS, it be tracking only with to monitor any contact that he might have with the two no contact subjects in the case.
All right. This is what the court will do. There's a $75,000 bond, which is agreed to by both parties. There's to be no contact with the complainant in the instant case or in the allegation of the new number one. There's to be partial GPS, waive fees, and that is for attorney consultations. Is there anything else?
I think for the state judge.
So,
Judge, may I ask that that partial be extended to any employment provided proof of employment is provided to the tracking provider? Or
once there is employment that has been obtained, then the court will consider that at that time.
Thank you, Judge.
All right. So what that means is you're allowed to go speak with your attorneys. That is it. So if you drive to your attorney's office and you see an HEB and you're like, I should stop at the HEB. You're not allowed to do that. You must leave from wherever you're stationed with your GPS. If it's at your home and you have an appointment with your attorneys, pretrial services is going to want to know of that appointment. And then you are to leave there without making stops to meet with your attorneys. Do you understand? Is there anything that you do not understand about the court's orders? All right, so you'll be back on December 11th. That will be for a contested hearing. Both parties will be prepared to proceed at that day. All right, is there anything else from the state or the defense?
I think for the state. Yeah.
Nothing from the defense. Thank you, Judge.
All right, thank you. All right, you're excused.